Good afternoon, everyone. As you know, I am the Provost and Vice President Academic, and it's a pleasure to be that at this university. And I'm really more pleased to be here this afternoon with you to just share a few words and a few thoughts. So I'm going to play in two parts. I'll play on script, and then usually the more interesting part is off script, which I want to save for the end. I would like to express my appreciation to Elders Louise Haff and Norm Fleury for your support and blessings of the day. Thank you, Louise and Norm. I would also like to thank our performers. Oh, by the way, the oxygen for the performers is at the back of the room. I don't know how they went through that. It was exciting for me. Through the lunch hour, Sheila Porsche and with Gabriel Dumont Institute for helping and planning the committee secure these talented individuals for this event. And greetings and also much thanks for the 4 individuals who have agreed to serve as witnesses. We look forward to hearing you and what we've heard from us and to your words of wisdom at the end of the day. Miigwech. To Eugene Archon, Traditional Knowledge Keeper, Reagan Rat Misponas, the President of the USSU, Marilyn Poitras, Director of the Native Law Center, and Brian Kashur on University Relations. This morning we experienced inspiring storytelling from our keynotes and engaging dialogue with a focus on action. What can we do individually and as an institution to move reconciliation to the next level? And for some of us to begin this journey. I am pleased to be here to participate in this afternoon's presentations and thoughtful and honest conversations, to learn from the insights of these remarkable speakers. As President Stoichev mentioned this morning, the conversations that we are having are being captured by note takers, and more ideas are evident on the walls. The themes that emerge will inform the university and will provide us with ideas to put back into action, which is what this is all about. I would like to have you join me for a moment to honor the Indian residential school survivors. It's important that we recognize that truth and reconciliation calls to action would not have happened without them. Their strength and resilience is truly remarkable. The residential school reality is part of our reality today. It's not something that happened hundreds of years ago. The last residential school closed in Saskatchewan in 1996. If you do the math, that was not a long time ago, only 24 years. And if you're 29 years old, you could have attended Gordon Residential School. You're Punishee, Saskatchewan. There are members in our university community, Indigenous student staff and faculty that were forced to attend these schools. Residential schools were created to remove Indigenous children from their parents, from their influence of their own culture, to assimilate them into the body politic. The goal was to remove the Indian in the child, or to kill it, in fact. These schools were open for more than 100 years, and the school-related deaths during the time are just estimates are recorded upwards of 6,000 children. Primarily because of an amendment to the passage of the Indian Act of 1884, these schools became compulsory. It is important to have meaningful conversations and to learn about the impact of residential schools and the legacy they leave for us. This is the foundation of reconciliation. Today's event is appropriately named in English, Let's Cross This Together. So let's build bridges and work together to realize the truth and reconciliation calls to action. Let us honor and hold high the survivors. And let's listen with open hearts to their stories of survivors when they are gifted to us, which they are. And let us not forget that they did not make it. I am humbled to be here to hear this with you. I want to share a last comment. And this is, as I said, off script related to this. I was thinking about this the last while. And for many in this room, especially the ones who've been around a while, we hear a lot of words. And the words to me, ladies and gentlemen, quite often are noise. I hear a lot of words. The only time I start paying attention is in that noise is when I start seeing a signal that might bear something that we need to listen to. And that signal has some consistent properties around it. And one of them is action, one of them is empathy, and the other one is engagement. Once you see someone speaking, or a group speaking like today, which is not noise, it comes from the heart, it comes from a place where action is needed, and where a voice can speak as one, that signal comes out and jumps on top of you because of its clarity and the vision of what we need to achieve. What we are doing here today, and we consistently have to do, is remind ourselves that true reconciliation reminds us to constantly find that signal of truth, of action, and the call to action that it requires from all of us, and to stay on it. Because the signal, ladies and gentlemen, can get dim if you don't stay on it. You have to pay attention to it, work on it, and remind yourself that this is what is important. And this is what today is about. And I'm glad to be here with you this afternoon and with the rest of the wonderful speakers to remind us of what is real truth and what is real focus that we need to have, and that we stay on that for a long, long time. Thank you very much for listening to me.
So that was a delicious lunch. Thank you very much for the wonderful lunch. I'm not bursting out of my shirt yet. So my ex had actually got me this shirt for Christmas. And at the time, I swear, I didn't fit it. And I was actually kind of embarrassed because I couldn't fit the shirt. And I was actually even more embarrassed because I thought, do you even know me? Do you even know who I am if you don't know what size I am? We ended up breaking up over that. But we're still talking, and that's reconciliation. So next, I would like to invite, once again, our former National Chief, Phil Fontaine, to introduce our next speaker.
This guy could have a future as a stand-up comedian. Anyway, I have the distinct honor of introducing my lifelong partner, my wife, Professor Kathleen Mahoney from the University of Calgary. She's been a professor of law at the university for a good number of years. I'm not going to say the exact number. But she's been a long-time faculty member. Outstanding professor. I've had occasion to attend a number of her lectures, and they're informative, they're inclusive, they're respectful, and this is particularly so in the last couple of years where she's been charged with carving out space at the university for Indigenous legal traditions, the Indigenous legal framework, and an entirely new field of study at the university. So it's been an incredible challenge for Kathleen to engage with her students in setting the course for the future in terms of learning about Indigenous legal traditions. She's non-Indigenous, so it spells out with some clarity that this is an extra challenge. And I know that she's learned a lot from what has transpired at the University of Victoria. And she's had people from the university come to the last time a fairly significant, not fairly, a very significant conference at Banff. And we had some good opportunities to learn from those good people there. So that's Kathleen, as I said, my lifelong partner, my wife, and he's just a wonderful, wonderful person. Loving, caring, respectful, demanding. Last reference was just a joke. Not true. So, in my presentation this morning, I mentioned that there are people that go unmentioned, but are significant, very significant contributors to the work that we engage in. And I mentioned Eugene Arcan, Elder Arcan, this morning. And his incredible contribution to making the TRC a success, particularly the calls to action, and establishing a repository or a center for the stories that are being told and will be told about personal and individual experiences with residential school. Now, another little-known fact, when we talk about the Truth and Reconciliation Commission, the historic Indian Residential School Settlement Agreement, the chief negotiator for the settlement agreement was Professor Mahoney. We weren't married then, so there's no conflict then, none. And she did a masterful job in negotiating our position, keeping in mind that I remember being at one meeting, there are 80 lawyers around the table, 80. And can you imagine the noise there? It was absolutely incredible. And of all of the legal counsel that was present there are plaintiff lawyers for the churches, for the government, for individuals, and others. Our team, the Assembly of First Nations team, was the only one with survivors, elders, and all of the people that we considered integral to our process and setting in place the terms and conditions that would make the Indian Residential School Settlement Agreement what it is today, the largest settlement in Canadian history, the largest class action lawsuit probably in the world. It's $6 billion plus, and absolutely amazing. And in large measure, that was due to the incredible insights that were brought to the negotiating table with Kathleen. And in particular, I want to mention the Truth and Reconciliation Commission and how it came to be a part of the settlement agreement. There was no talk about the Truth and Reconciliation Commission. No one was interested. The lawyers that were there had no interest in the TRC. Some of them were vaguely aware of the South African experience. No one knew that at that point when we were negotiating that there were 63 truth commissions or truth and justice commissions and the like in the world, 63. And no idea, no interest. Most were interested in the monetary compensation. But Kathleen pursued this notion, this idea, this concept that the Indian Residential School Settlement Agreement would be incomplete if we didn't have a Truth and Reconciliation Commission. And so the structure that emerged, not the piece that Justice Sinclair and Chief Littlechild and Marie set out. I mean, that was largely their work, and congratulations to them. But the grounding, putting in place the measures and the procedures that needed to be in place and expressed in the settlement agreement was the incredible work by Professor Mahoney. And so I thank her publicly for that. I've never done that, and I didn't want to embarrass her, and because she's a humble person. So we owe a lot of credit to Kathleen for her work regarding the TRC in particular. Thank you. I present to you Kathleen Mahoney, Professor.
Well, that's quite a bit to live up to. Thank you so much, Phil, for that. Needless to say, I may have been leading negotiations, but our leader was Phil Fontaine in every single respect. However, I'm not going to take a lot of time because I want to be able to show you a video, and I've got about 30 minutes, so I'm going to try to contract my presentation so that we can show you that. But I do wish to thank the organizers for this tremendous event, and thank you for the honor of the invitation. I really, really appreciate it. Your Honor, thank you for your words, and also, obviously, I recognize the President of the University and all the wonderful people here before I start. So what I'm going to talk to you about today, the title is The Indigenous Solutions That Led to the Largest Settlement in Canadian History, the Untold Story. And I think it is largely untold. We all know about now what happened in Indian residential schools, and we all know largely about the settlement. But what was behind all of that, I think, is largely untold. And I'm a law professor, so I'm coming at this from a legal perspective. And what is also quite becoming to be well known now is that Indian or Indigenous laws existed for thousands of years before colonization. But with colonization, of course, a legal system was imposed, and the Indigenous legal system was set to not even just to one side, it was essentially buried. But more and more people are beginning to recognize, yes, there's definitely a legal system there, and law schools are beginning to talk about that. The big question now remaining is, how do we apply those Indigenous legal principles in a meaningful way going forward? So this is basically what I'm going to talk about, because the Indian Residential School Settlement Agreement is based in Indigenous legal principles. That's what most people don't realize at this time, and that's what I'm going to try and help you with. So here's the overview of my talk. First of all, we had a 150-year-old problem. After Phil Fontaine's public disclosure, it became more and more apparent after OCA, after RCAP, that something needed to be done. And it was a legal problem that we had never faced in the country before. The second point I want to talk, and I'll talk a bit about that. The second point I'm going to talk about is why the system we have, the formal Canadian system, was not the answer to this problem. Thirdly, I'm going to talk about the negotiations that took on the Indigenous approach and how those legal principles were used in the negotiations. And finally, I'm going to talk about the outcome. And my argument is that it was a win-win outcome, and which never otherwise would have occurred using the mainstream system. So the problem we've heard from many speakers was the cultural genocide that happened over 150 years. And it was clearly Canadian public policy at the time, and there's no hiding it. So that was the problem. We know how it was implemented. All of these legal wrongs were committed in terms of certainly the abuse, but there were so many other things that went on that weren't legally recognized as wrong. But this is a list here of some of the things that kids experienced in those schools. The spiritual and cultural practices that were forbidden, forced separation, forbidding of the use of language, the rampant abuse, and the overall cultural genocide. So why wasn't the legal system able to deal with this problem? Well, first of all, in terms of the survivors themselves, to go through a trial, and I don't know if anybody in this room has gone through a trial, but if you have, you'll certainly agree with me that trials in our system are very prolonged and deeply troubling and not very pleasant affairs, especially if you happen to be complaining about things like assault or sexual assault. The cross-examination process, the discovery process, all of that is humiliating, embarrassing, and it's often far too much to contend with. Secondly, we work with burdens of proof in law, and you probably are quite familiar with this watching TV and so on, that in criminal matters the burden of proof is beyond a reasonable doubt, which basically means there can be no doubt that it happened, and in civil law it's balance of probabilities that it happened, both of which are very, very difficult to meet if things happened many decades ago and people's memories have faded, witnesses have died, and so on. Also in our system of law, it protects perpetrators more than it protects victims. So there's many, many protections for perpetrators in the law. For example, limitation periods. Until very recently, you couldn't take a sexual assault case if 6 years had passed. There's other limitation periods. There's Crown immunities. The Crown was immune from being sued for many, many years until the middle 50s. And still, in some instances, there's Crown protection. So you just can't sue the government. So we had all these things, we have all these things in law that discourage people from suing. On top of that, these victims in this particular case were largely impoverished people and facing defendants with unlimited resources. The churches had many, many resources. The Catholic Church is one of the most wealthy institutions in the world, I think next to the royalty in England. And certainly the government had unlimited resources, and their individual impoverished people were up against this type of defendant. Trials take long delays. The famous Blackwater case took 6 years of litigation. Enforcements of judgments, even if you win in law, you have to enforce a judgment. And often that's next to impossible. So you go through this whole trial process, you get a judgment for X dollars or whatever you're looking for, and you can't enforce it. The defendant could be dead, the defendant could be impecunious, the defendant could be in jail, and so you're left with nothing. And on top of all of that, the reparations or the remedies are very, very limited in law. Basically dollars. The way in which civil law deals with problems is to give people money. Trouble is, money can't replace a broken heart. Money can't replace a lost childhood. Money can't replace psychological PTSD problems and so on. So the range of reparations are very, very limited. So there's a whole bunch of reasons why normal litigation in the Canadian way was not possible. And especially if you look at the kind of harms that the survivors suffered in residential schools. And there's a big long list here on one side, and those were what any lawyer or law professor would say, okay, well that's interesting you had those losses, but I'm sorry, the law doesn't cover that. And that would be things like loss of your family, loss of your community, culture, languages, loss of income and opportunity you can claim, it shouldn't be on that side, but intergenerational harms, dignity loss, trust, the loss of history, relationship losses, spiritual losses, growing up in a climate of fear. Those are the kinds of things that our legal system does not address. What it does address are those very limited bullet points on the other side. It addresses serious physical injuries, and it addresses sexual and some psychological abuses. So the legal system we have is very limited. So what to do when faced with this cultural genocide? The AFN, Phil was at that time the national chief. He could see that this was a unique opportunity that would never arise again. And for 14 years, these cases had been languishing in various court proceedings. They were run largely by large law firms around the country, a handful of them, taking class actions, and there was a number of individual actions out there. But when you looked at how those cases were proceeding, there was no widespread consultation with survivors. Class actions, as they are, have one representative plaintiff in name, and then they're to represent the whole group. And even class action lawyers will tell you there's usually very little discussion between the named plaintiff and the lawyers. So the way the system is set up, there's very little ability even to consult. Lawyers are interested in making money. They run a business, and so maximizing the monetary remedy is their main focus, and that was certainly the case here. The other Indigenous values of healing, inclusivity, transparency, and certainly reconciliation were not even talked about in the lawsuits that were being put forward. So when the AFN looked at this and the courts were being clogged, the Justice Department was in panic because they thought with all these class actions and individual lawsuits, it would take about 53 years for them to get through the courts if that's all they did. So there was a huge pressure from the Justice Department. Something had to be done. So they went to Phil Fontaine as National Chief and said, "Can you help us?" So he saw this as an incredible opportunity to do things the right way. And so he told them that if AFN was to get involved, it had to be a transformative process. Transformative for the individuals involved, transformative for communities, Indigenous communities, and most of all, transformative for the country. So Indigenous legal principles then became the new starting point. Because as I've told you, what we have, the status quo, would not in any way address those needs. So there came a point after a certain period of negotiations, actually secret negotiations between the AFN and Canada, a political agreement was signed. And this was a very major turning point that most people are completely unaware of. It's not even on the government website. It's on my website if you want to read it. But if you notice, this picture is very important. This was the day that political agreement was signed. There's Irwin Cotler, who was the Minister of Justice at the time, the late Andy Scott, who was Minister of Indian Affairs, and the Deputy Prime Minister, Anne McClellan, along with Phil. And as you can see, he's the only one smiling in the picture. But then that was the status quo. That was the mainstream political agreement. You can see all the important people are there, the Canadian flag in the background. This was right across the street from the Parliament buildings where this event took place. But then this was the most important event. This took place on a reserve in Kenora with the very famous elder, Fred Kelly. And Frank Akabuchi by this time had been appointed because it was a term of our political agreement. That's who we wanted. And there was a ceremony there to consecrate going forward in the Indigenous way. As you can see, both of the National Chief and the government representative are in blankets. The women of that community carried the government representative into the room. The ancient pipe was smoked from Treaty 3. Singing, dancing. We took the government representatives, the AFN team, and others were there, danced and sang and prayed for a proper result from these negotiations. Following this particular meeting, as you can see, it's not a government building, it's a log cabin with a skylight. We went to the reserve of the National Chief, the Saugeen Reserve. We all got into cars and drove down there and had a public meeting with survivors where they were given the opportunity to question what was going on and how things were going to unfold. So this was the way in which the National Chief insisted, along with Fred Kelly, that this is the methodology that had to be followed going forward. So what were the Indigenous legal principles that were adopted? Now, I don't want to mislead you. It was very apparent to all of us that there's no pan-Indigenous set of legal principles or laws, but nonetheless, the Ojibwe way, which was the National Chief's background and our advising elder, was that the kinds of things listed here were very important, and our research showed us that notwithstanding the fact that different Indigenous groups across the country have different legal principles and laws, nonetheless there's some commonalities throughout. And consultation, of course, is a very common principle. We needed to go to survivors to find out what they want and under what terms. We had to have further outreach to elders and community leaders. Survivors had to form the core of our negotiating team, which indeed they did. The diverse Indigenous legal principles were honored as far as possible. Cultural norms were followed. and decisions were made in the process of deliberation, consultation, persuasion, and consensus. We reported back regularly to the AFN executive to tell them what we were doing. We went from coast to coast to coast to inform survivors. I remember one meeting in particular in Vancouver. We were at the hotel, I forget the name of it now, it's the one with the big, huge lobby, and we thought, oh, there'll be lots of room here for survivors. We expected about 200 people. Well, by the time we finished, there was over 1,700 survivors in the hotel. And most of them wanted to stand at the mic and tell their stories. The line went right out the door. So there was this kind of consultation that went on. Although it was not easy, it was something that was mandatory in terms of respecting Indigenous principles. And what we learned from those consultations and dialogues that were held that the government sponsored was to look back, but also look forward, to be inclusive, accessible, and transparent and fair, to be holistic and comprehensive in recognizing all of the harms. Remember that slide I showed you with just a few of the harms on one side and the big long list on the other? It was our view that all of those harms had to be acknowledged and dealt with in the settlement agreement. To respect human dignity and racial and gender equality, what the government was proposing was gender biased, it was very under-inclusive, it was not a good system, the ADR system they put out, but we were going to rewrite that and include these other equality mandatory elements. Had to contribute to reconciliation and healing, which is completely void in the tort approach, the mainstream law approach. And then we were told that we could not harm survivors and their families. These were the terms of the political agreement that the AFN signed with the government, as I said, after these series of secret negotiations before we went into the larger arena. And the government promised that the AFN would play a key and central role, and that reconciliation would be the ultimate goal of these processes. They said that the settlement agreement would have collective elements and it would be a reconciliation package, that the sick and elderly would receive payments first, never heard of in common law. Defendants would work and consult with the AFN to establish a truth and reconciliation process. The government will apologize. All of those elements were there before any negotiation started with any of the other parties. And that was basically the blueprint that was achieved in dealing with Indigenous-inspired values going forward. So all of a sudden now, in the settlement agreement, all of the harms were covered. All of those things we were talking about. On the left-hand side, I guess it's your right-hand side, I'll just stress, none of those losses would ever be covered by the British common law system, or French civil law for that matter. So what is in the agreement to reflect those harms being covered? Well, every survivor got something out of the deal. That fund was $2.9 billion and called the Common Experience Payment. And what we said was that this payment was for loss of language and culture and loss of family life. The government really, really rebelled against this. They didn't want to have any precedent that would be based on those terms, so they called it the Common Experience Payment. But it was, in our minds, it was always a payment for loss of language and culture and loss of family life, which every student that went to residential school suffered. The advanced payment for the elderly was included. Physical, sexual, and psychological abuses was the largest financial part of the deal. It amounted to about $3.2 billion, and approximately 35,000 people successfully claimed under this fund. The healing funds were $125 million. This was to extend the Aboriginal Healing Foundation. Lawyer fees were covered up to 15% of any settlement that the government would pay. Community commemoration projects were to get $20 million. Community education projects, $150 million. An education fund for intergenerational survivors was a fund of $250 million that was left over from the unspent money in the Common Experience Payment. Truth and Reconciliation Commission got $60 million, and there was provision for a National Research Center and Archive, which was one of the first things, as you recall from Phil's remarks, that he requested way back when he first spoke about this. So just to give you an idea of the comparisons, the government ADR, which they thought was going to solve the problem, for eligibility, they would have only seen about 15,000 people as being eligible because they'd had no common experience payment in their plan, and they thought that there would only be about 15,000 survivors that would be able to claim physical or sexual abuse that was compensable in law. The settlement agreement based on Indigenous legal principles resulted in 104,000 survivors getting compensation. And of that 104,000, as I said, 35,000 got additional compensation for physical, sexual, or other individual abuse, and the balance was the collective harms of loss of language and culture. The average compensation for the abuse claimants under the government ADR plan was $47,000. Whereas the settlement agreement based on Indigenous principles, that came up to $105,000 average. The difference between the two was that we insisted on a lesser burden of proof. We insisted on an adjudicative process where it would be much more user-friendly, there would be health supports, it would be culturally relevant, and so on. There's many other elements, but I don't have the time to go into them. But that, in monetary terms, was the difference. The compensation for physical and sexual abuses, that the global amount in the government plan was $1 billion, and the settlement agreement that we negotiated based in Indigenous principles was $2.8 billion. Okay, I don't want to go there. So there's another, that can't be moved up, I guess, that slide. In any event, I didn't want to dwell too much on that because this was just the compensation portion of the package, but I just wanted to show you, even when it came to compensation, dollars and cents, the Indigenous methodology resulted in a far better package at the end of the day. As I said, we negotiated the apologies in the political agreement, and that came to fruition. Phil has already spoken about that in the House of Commons, where for the first time in history, Indigenous people sat on the floor of the House of Commons and heard not just the Prime Minister, but all the leaders of all of the parties give a fulsome apology. And then there was the apology from the Vatican, which, again, was not an easy thing to achieve in terms of making this happen. Many, many consultations took place and discussions which finally culminated in this event. The Truth Commission report, again, probably most forcefully grounded in Indigenous principles, led, of course, by famous Judge Murray Sinclair, and the 94 calls to action address all of those systemic issues that Indigenous people have faced almost since point of contact. So if you read the 94 calls to action, which I see are up on the wall, you'll see that they can be categorized in these categories of virtually every systemic area in which we live. And that's where the reconciliation will take place. So the way I saw this, I mean, it's not a perfect settlement, and as Phil always counseled us going through these negotiations, perfection is the enemy of the good. So we couldn't get lost in looking for perfection. It doesn't happen in negotiations. And negotiations are just that. So what we were looking for was something that was good, something that was transformative, something that would last, and something that would impress upon the country the idea that Indigenous solutions are the best way in which to deal with these types of problems. So the win on part of the survivors, I've listed a number of things there. A lot of the wins were because they didn't have to deal with courts. They didn't have to deal with litigation. They got to tell their stories. That was the number one request that survivors had when we consulted with them across the country. They wanted to tell their stories. And that's what the Truth Commission was designed to do. There was less trauma than litigation would have. Reparations would happen. They wouldn't end up with a judgment that they couldn't enforce. They would happen, and they would happen sooner. All harms were addressed according to Indigenous law, which was a win because, of course, it made a huge historic moment in the legal history of this country. Intergenerational harms were acknowledged and addressed in the settlement. Again, something unknown to law. And claimants could begin to heal. The word heal does not come up in our legal discourse at all. There's no such thing as a legal right to heal or a remedy that's designed to heal people. It's considered to be just compensation or reparation. It's not considered to have a verbal result or a verbal connotation to it. But healing and reconciliation was part of this, that at least that was considered and put into the agreement itself. It's also a win, I would say, for the defendants, because the settlement agreement allowed them to come to an honorable conclusion, or an honorable result at least, of this terrible history that Canada had participated so vigorously in over so many, many years. Similarly, they could walk away with an enhanced appreciation of the cultural differences that exist in Canada. And they could see that there was a path forward to reconciliation through the results of the Truth Commission. So in many ways, it's a long-term investment for the country. And so that has to be a plus for Canada. And we made that point over and over again. Also, even from a crass financial point of view, it cost the government. One of the turning points of the negotiations, which probably shouldn't surprise you, was we told them our system, even though on paper it looked like it was going to cost a lot more, in fact, we said it would cost less. And we got KPMG, we had them agree with us that if we picked an independent third party to look at what we were proposing and what the government was proposing, we would see what KPMG had to say about it. They said that ours was the best plan. It was less expensive in the long run if you gave value to things like less confrontation, more reconciliation. And as well, continued litigation with no end in sight. It was also a closure to a period of time and a period of great liability from them. So that was a turning point in many ways. I hesitate to say, but it's true that the monetary savings was an important point. So for them, you could say that was a win. And then probably the biggest win is that it created awareness in the general population about what went on in our history. It was almost an existential crisis for a while. I think Canadians thought that, as we have all been taught that are non-Indigenous people, that Canada is this wonderful, peace-loving, equality-enhancing country that the whole world looks up to. Well, all of a sudden we were faced with something that wasn't quite that. So it raised awareness. I don't know how many of my students told me, oh my goodness, I never knew anything about that, and even my colleagues at the university. So it was something that was hidden in the dark, and the settlement agreement shone the light of day on our history, and it's made the Canadian public much more aware, and I think much more supportive of the issues that we're facing on a daily basis. So if you want to read more about the untold story, I published a long article about it, going through all the legal alternatives there were and how they were all dead ends. It's in the 2018 University of New Brunswick Law Review. So I'm going to conclude there, but I want to show you a video because I think it is so, it's so much a summary of Indigenous principles. The video is called Forgive. There's a little bit of nepotism involved because my daughter at the time was a graduate student at Ryerson, and she was doing a film for her master's thesis. So she asked us if she could come to Rome with us to hear the apology of the Pope. And so she did this film. It's won a number of awards around the country, and it involves Phil's journey in terms of the residential school and his attitudes towards, are you going to set it up? Yeah, and so I think that it's very much a nice way to conclude this talk, but also when you talk about action and how people should react to these kinds of initiatives on the part of the university to advance the cause, I think this is a very important message. The movie's called Forgive.